In today's video, I will discuss the rules that govern what happens to real estate in Texas when someone passes away without a will. It's not the most popular of subjects, but it is one that you should be familiar with. Stay tuned. Thanks for joining us again for Coffee with Capital. My name is Kelly Yount, attorney with Capital Title. So what happens when someone passes away intestate, meaning the deceased had not left a will in place prior to death? The Texas Estates Code controls who gets what in the event of a death without a will. The first step in discovering who gets what is to first determine if the property is community or separate property. The community property presumption states that all property acquired during marriage is presumed to be community property unless proven otherwise. Separate property is usually property that was owned before marriage, inherited, received by gift, or divided by written agreement. Another important detail in determining who gets what is the magic date of September 1, 1993. Just keep in mind if the decedent passed away prior to this date, the intestate rules are different for distributions. Let's go over a few examples to give you an idea about how the above factors can make a big difference in determining who gets what. In our first example, husband and wife owned a community property home. The husband passes away after September 1, 1993, and the wife was the mother of all the children. The entire property will go to the wife. The surviving spouse retains their half community interest and inherits the deceased spouse's 1/2 community interest. Now let's use that same example, but now the wife is not the biological mother of all the children. In that situation, the wife will retain her undivided 1/2 interest in the community property, and the husband's undivided 1/2 interest is divided evenly among the children. Let's change the scenario further to make the property the separate property of the husband. Here, the wife would retain a life estate only, and the kids would inherit 2/3 outright in equal shares, and they also have a remainder interest in the wife's 1/3 life estate. Finally, let's make one last change. This time, the husband died prior to September 1, 1993. The property is community, and wife is the mother of all 4 children. Here, the wife retains her undivided 1/2 interest, but the husband's interest in the community property is divided evenly among the children. So you can see that that date of death, the character of the property, either community or separate, and knowing if there are any children outside of the marriage can make a big difference when it comes to estate distributions. And note that any children legally adopted inherit the same as a biological child. Now keep in mind that if there is a will, the will trumps the intestate succession rules. Join us for our next segment where we will dive into wills and basic probate procedures. I hope you found value in today's message and truly hope that you will be joining us for another cup soon. If you have a question or concern, please feel free to leave it in the comments section below. You're also welcome to reach out using my contact information, which you will find in the description of the video. Thanks for joining us, and we hope to have you join us again next time. Enjoy your day.